welcome back to the legal video series presented by the Law Office of Joseph Abrams. I'm criminal defense attorney Joseph Abrams, and I answer your most common questions about federal criminal law in easy to understand terms. So let's take a look at today's question. There are two principal reasons why penalties for drug offenses are more severe in federal court. The first reason is the statutory penalties themselves. The other reason has to do with how drug offenses are treated under the federal sentencing guidelines. So let's take a look at both of these. First, the statutory penalties. Most federal drug offenses carry statutory minimum sentences that are binding on the sentencing judge. Depending on the quantity of drugs involved in a case, the statutory minimum sentence can be as high as 10 years with a maximum sentence of life imprisonment. In lesser cases, the statutory minimum sentence is 5 years. Only in rare cases with relatively small drug quantities are there no minimum penalties. The effect of these minimum sentences is clear, and that is that even if there are compelling mitigating factors in a case, such as a defendant's motivation for committing the offense, or perhaps a defendant's mental health and substance abuse history, no matter what the circumstances, the statutory minimum sentence must be imposed. Now, let's turn to the federal sentencing guidelines. First, the guidelines treat drug offenses harshly, and this largely reflects the stiff statutory penalties prescribed by Congress that we just discussed. Second, in addition to the drug quantities that a defendant pleads guilty to, the guidelines may hold the defendant accountable for additional drugs from dismissed charges and even from uncharged conduct, so long as it was from the same course of conduct or common scheme or plan. Additionally, the guidelines may also consider drug quantities possessed by other persons, so long as they were engaged in joint criminal activity and the other drugs were foreseeable to the defendant. In sum, between the statutory penalties for federal drug offenses and their treatment under the sentencing guidelines, a drug defendant, even in a case with mitigating factors, is very likely to receive a severe sentence. Now, there are some limited circumstances where a defendant may be sentenced below the statutory minimum sentence, but that discussion is beyond the scope of today's question, so perhaps we'll tackle that issue in a future episode. This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening. I hope you found it helpful, and we'll see you next time when I answer another of your questions about federal criminal law.